Rosenfield program in Public Affairs, International Relations, and Human Rights. The Rosenfield program is honored to organize the college's Constitution Day event. Today is the 230th anniversary of the signing of the U.S. Constitution, hence the mock champagne. But as you know, having a draft of the Constitution, which is what we're commemorating today, as momentous as that was just the beginning of more than 2 centuries of debate about the reach of the state, about the processes and structures that the Constitution designed, and about the power that it allocates across institutions. In this session today, we ponder presidential power, in particular the president's power to pardon. This is hardly a new question for the Republic, but Constitution Day 2017 is an especially timely juncture to consider the pardon, with President Trump having already used it in an especially controversial case, and with the prospects before us of other contentious applications. Today we will hear 2 legal experts discuss the presidential pardon. Professor Andy Grewal is professor of law at the University of Iowa, where he is also Joseph F. Rosenfield Fellow in Law. I was saying Joseph Rosenfield. Professor Grewal specializes in tax, but has graciously agreed to weigh in on this timely topic. He was an undergraduate at Williams College, holds Master's of Law degree from Georgetown University Law Center, and a Juris Doctorate from the University of Michigan. Professor Grewal is joined by Professor Brian Kalt. Professor Kalt is Professor of Law at Michigan State University, where he is also the Harold Norris Faculty Scholar. Among Professor Kalt's areas of expertise is structural constitutional law, and he has been a go-to voice this year on the topic of the presidential pardon. Professor Kalt is a graduate of the University of Michigan and holds a Juris Doctorate from Yale Law School. Today we'll hear from both of them and then open the floor to questions from the audience. So please join me in welcoming our guests.
How are you guys? So we're going to talk about various things related to pardons. You may have seen Brian on CNN or elsewhere giving a spiel on why the president can't pardon himself. The Constitution, I suppose, is technically silent on this question. If you read it, it contemplates that the president can grant pardons for offenses against the United States. It doesn't say, but not himself or herself. And in our modern environment, I suppose we've been thinking a lot about whether the current sitting president could potentially grant a pardon to himself if he were indicted, charged, or other bad acts were alleged. I know that Brian has thought extensively about this, and maybe I'll start off by turning it over to him and give your elevator speech on why this actually is not permissible. And I'll probably push back a bit, and hopefully we'll have time to discuss other aspects of pardons. What if he pardons his associates, other members of the White House? Are there any limitations? I should say at the beginning that we are speaking hypothetically. I don't have any facts. We have an investigation. And in talking about a pardon, I certainly don't want to imply any jumping to any conclusions. But the legal question we can talk about openly and have a good debate on.
Well, if this is my elevator speech, then it's a very slow elevator and a very tall building. But I'll try to keep it as compact as possible. I actually first wrote about the question of presidential self-pardons, just to drive home the point about this being hypothetical, 21 years ago. And it was important to me at the time to write it in a hypothetical context, because the best legal arguments that I could come up with were ones that I could come up with not knowing who the president was. Did I like the president or not like the president? Did I agree with what he had done or not? If it becomes not hypothetical, most people then are concerned primarily with who wins, not with the particulars of the legal arguments. I was concerned with the particulars of the legal arguments. And I should say my answer to the media when asked, when they say, can the president pardon himself, is, well, he can try, because we don't know. No president has done it. At least one president has contemplated it, had his lawyers write up a memo about it, but we don't know. So my argument that the president can't pardon himself is basically my argument for if I were a judge hearing that case, why I would rule against the validity of a self-pardon. And there are three main parts to the argument. One is based on the text of the Constitution. One is based on some principles, you could call them common law principles. And the third is a historical or an original intent argument. And the textual argument is that if you pardon yourself, that's not a pardon. That a pardon is inherently bilateral. It's inherently something you give to someone else. Similar to if you give someone a lift to the airport, right? You can't give yourself a lift to the airport. That doesn't make sense. You could call it that if you drive yourself to the airport, but it doesn't make sense. That's not what it is. The Latin root of the verb to pardon, perdonare, has two other verbs that are derived from it, to condone and to donate. And both of these, too, I think it's you can say the same thing. You can't condone your own actions. It doesn't make sense. You can't donate something to yourself. It doesn't make sense. If you want to donate something to yourself, you have to set up a separate legal entity that you control and donate it to that, because you can't donate something to yourself. Pardons work the same way. The pardon power, getting a little highlight of the historical argument, the pardon power is derived from the royal pardon power the King of England had. The King of England never had any ability to pardon himself because the king could do no wrong. He had nothing to pardon himself for. So in the very notion of the pardon power, this bilateral relationship between a sovereign and a subject. The second argument, what I call the common law argument, is based on two principles that judges base their decisions on when they follow these principles. When they don't, they conveniently forget them. So I recognize there are arguments on both sides here, but two important principles, things that I would rule based on were I a judge in a case like this. And the first is the rule of law. The notion that a president could pardon himself, to me, is a threat to the idea that we are governed by laws and not by men. And the reason that it's a threat to the rule of law connects with the other principle, which is an old principle that no person can be the judge in his or her own case. And we see this elsewhere in the criminal apparatus. If you are accused of a crime, you are accused by a prosecutor, indicted by a grand jury, tried by a judge and a jury, perhaps pardoned by a president. In each case, you could not be one of those decision makers in your own case. You cannot be the prosecutor in your own case. They would have to find someone else to do it. You cannot be on your own jury. You cannot be a judge in your own case. Again, this principle, if we extend it to the president, would say if the president wants a pardon, he has to get it from a president other than himself, right? His successor as president. The Constitution has a lot of very specific provisions, and so sometimes people say, well, there's nothing specific that says he can't pardon himself. So why are we going to read this implicit limit in? And I would just note two things quickly. One, there are other implicit limits in the pardon power. One is, for instance, you can't pardon someone for something he hasn't done yet. You can't say, I pardon you for the bank that you're going to rob next week. You can't do that. You can only pardon things that have already happened. It doesn't say that anywhere in the Constitution. It's just implicit in the definition of a pardon. But there are also implicit limits, I would argue, based on this notion that a person cannot be a judge in his own case. An example of this, impeachment. The Senate is presided over by the Vice President of the United States. The Vice President of the United States is the President of the Senate. There is one exception to that. When the President is being tried by the Senate in an impeachment case, the Chief Justice presides. Because it would be a conflict of interest for the Vice President to preside over a trial, the result of conviction being that he would become President. So the Constitution substitutes the Chief Justice. So my question to you is, who presides over the trial in the Senate in an impeachment case if the Vice President is being impeached? If we say that the Constitution makes one exception, only if the President is being impeached, and other than that, the Vice President presides, then you have to accept that the Vice President would preside over his own impeachment trial. Now, maybe you accept that. Maybe you think that would be okay. I've heard it argued that it would be. But if you think the President can pardon himself, then you have to accept that result as well, that the Vice President could preside over his own impeachment. I think that is an example of how I would assume, of course it would be the Senate deciding for itself, not the court. I assume that the Senate would not allow that to happen because you cannot be the judge in your own case. That principle is deeply rooted in our structure of government enough that they would apply it, even though it's not in the Constitution. Finally, and very quickly, the historical argument. When the framers were drafting the pardon power, they did not discuss self-pardons. I would argue it's because they didn't think, they literally thought it went without saying that the president could not pardon himself. But they did discuss the possibility of presidents abusing the pardon power. And one of the things they decided to do was to give the president a broad pardon power with virtually no limits. And this was strange, because we had just fought a revolution against a monarchy because it was a monarchy, and state governors in the state constitutions that had been written to that point tended to have greatly reduced or weakened pardon powers. But then they came in and they gave the president this royal power. And someone argued in the convention, well, this isn't right. What if we eliminated the president's power to pardon in treason cases? Because what if there were a bunch of traitors and the president was using them? They were rebelling, they were working for him. The president is a traitor, and you're going to let him pardon all these other traitors working for him? We can't do that. And the response to that was, yes, we can. Because if the president does something like that, he can be impeached. And he can be prosecuted. That was the argument. And they voted and they said, okay, let's not limit the pardon power. Implicitly then, let's rely on impeachment and prosecution if a president should abuse the power that badly in the exercise of some criminal enterprise. If anyone in that room had thought that the president could pardon himself, that argument would not have gone unanswered, let alone carry the day. So although they did not ever say specifically the president cannot pardon himself, I believe the evidence shows that they understood that the Constitution that they were writing was not giving the president the power to pardon himself. That's as I said, long elevator ride, tall building, but that's the ethic.
Let me ask you about this hesitation regarding the president being his own judge. Isn't that already the case? That is, if the president committed some type of federal offense for which the statute of limitations was 2 or 3 years, he's not going to get prosecuted, assuming that it occurs in year 1. He would be in office for 4 years. Statute of limitation refers to the fact that there's a set amount of time under which you can be prosecuted for violating the law, and once it passes, it's done. In these circumstances, would you how would you deal with the fact that the president is the chief prosecutor of this entire country, and he effectively does get to judge, at least sometimes, whether he should be prosecuted?
So I wrote a book, also hypothetical, I guess 5 years ago now, called Constitutional Cliffhangers, a legal guide for presidents and their enemies. And chapter 2 is, can the president pardon himself? Chapter 1 is, can the president be prosecuted while he's in office? And if it's a federal prosecution, then we have to assume either that the president has consented to be prosecuted, which would seem unusual, but maybe for political reasons he wouldn't stand in the way, or there was an independent counsel, and the president was reluctant, again for political reasons, to fire the independent counsel. But in a situation like that, the president does have the ability to keep prosecutors at bay. I would argue that the fact that he has that ability is bad enough without allowing him to pardon himself and make that permanent, to project that past when he's in office. It's one thing to say that when he's in office, he has powers that might redound to his own benefit. It's another thing to allow him to project that power permanently in the way a king would, because presidents aren't kings. They're supposed to leave office at some point before they die. Further, I think this idea that a president might be able to prevent his own prosecution has some important limits. One, the statute of limitations might not run out. Two, there is political pressure placed on presidents who are facing criminal investigation. If he's not going to investigate himself, then Congress has a tremendous incentive to step up and get to that through impeachment. That's what impeachment is for. One of the main arguments why you can't prosecute a sitting president is that that's what impeachment is for. And you wait until he's not president anymore to have the criminal trial. But if it's a president that we're talking about, it's Congress who decides what to do about it. And Congress doesn't need to wait until his term is over. Congress can impeach right away. Whether impeachment power justifies a broad pardon power is another issue I think we'll get to later. But I think you make a good point, but I think that it doesn't extrapolate.
Well, let me ask you about King Joffrey. You guys watch Game of Thrones? A very evil young king who, I guess I shouldn't give away any spoilers.
I've never seen a single episode of Game of Thrones, so anything you say will be a spoiler.
He is or was a very, very bad, cruel person. And let's assume that we have a president who, in his final months in office, is very concerned because the people have elected King Joffrey to replace him, not it would be President Joffrey. And he may be concerned that the next person coming in is a madman or mad woman, and I need to pardon myself because Joffrey is going to come after me. And maybe he may believe rightly that the claims would be frivolous, but people don't want to be prosecuted even if they believe that they will ultimately be vindicated by courts. In these circumstances, it seems perfectly plausible to me that a president, for an entirely non-nefarious reason, would want to pardon himself or herself. You've got Joffrey coming in. In these circumstances, you contemplate that this self-pardon would be a threat to the rule of law. And I suppose we could imagine circumstances where it would be, but it doesn't seem to be necessarily the case. How would you respond to that hypothetical?
And that is close to the hypothetical in Chapter 2, where the president is on his way out. The new president came in promising to investigate. President Trump has talked about investigating Hillary Clinton. She wasn't the incumbent, though, so this is a different issue.
Well, if you wanted to, you could say President Trump still hung on to the birther theory, and he said, I'm going to prosecute President Obama for claiming that he was born in Hawaii.
Sure.
So would it really be inappropriate for Obama to pardon himself?
The principle that, well, first of all, if you can't pardon yourself, you can't pardon yourself, right? The textual argument, if it's not possible because that's not a pardon, then it doesn't matter if you have a good reason for doing it. Just like it wouldn't matter if you had a good reason for pardoning something that hadn't been done yet. It's not a pardon, you can't do it. The idea that no one can be the judge in his own case, though, I think is similarly not limited to situations in which the judge would make the wrong decision in his own case. That is, the principle exists whether or not the right decision would be made. It's not to protect us from judges always getting it wrong. Maybe sometimes they get it right. The pardon power is given to the president. Remember, it was sort of strange that they gave this power to the president. The pardon power is given to the president because the president is the only person in the government who is politically accountable to the whole country. Members of Congress are elected by districts or states. The vice president, I suppose, is elected by the whole country, but has no real power other than presiding over his own impeachment trial. So the president is politically accountable, and so that's why the president has the pardon power. And so my reluctant conclusion there would be that if Joffrey were elected president, then constitutionally that is the decision of the people that he gets to decide who gets pardoned or not. The person who's replacing could pardon everyone else, certainly, and presidents recently, President Bush 41 and President Clinton pardoned a lot of people on their way out of office, but not themselves. And they could have. Both of them had things that they could have protected themselves. They were both being investigated by independent counsels. They could have. So I would say that would be a bad result if a new president came in and prosecuted the old president. I think that would be problematic in a lot of ways. But I don't think that that undoes any of the reasons why a self-pardon would be inherently invalid.
So on this point that if a self-pardon isn't a pardon, then that's the end of it, I suppose I agree with that, although we also agree that this is a question of some nuance. And I do wonder if, by looking at the king, it's a little bit of a square peg, round hole situation. And it is true that the king never pardoned himself because the king could do no wrong. And I suppose you can make the jump from that, well, the president can't pardon himself. But you could frame it a different way. The king's power was to pardon any crime that may have been committed or alleged to have been committed, and that's it. And if that's a principle we extract from the king's pardon power, that you can ensure that no bad act will be punished, will be pardoned, in those circumstances, a self-pardon makes perfect sense. Just pardon means making it so that crimes cannot be prosecuted. And if that's what a pardon means, then sure, what Trump would really be doing is not pardoning himself, but pardoning an offense. And in that circumstance, we can talk about it as being something external. I'm pardoning this prior act. It's not just pulling yourself up by your bootstraps. It's kind of a funny phrase that doesn't really make sense.
I agree that the dictionary argument is problematic, because if you say, by definition, a pardon is what I'm saying it is, that is sort of a bootstrap thing to do. Because the court could just as easily say, a pardon is not inherently bilateral. And how do you know this? Well, because we just said so, right? We're the Supreme Court, and we just said so, so now you know. But I agree, I think this is an important limit on my notions here. I agree that the pardon power in the United States is a policy judgment by an accountable elected official, not an act of grace by a benevolent sovereign. And the origins weren't benevolence, it was a good way to raise money when you were the king. But think about the Nixon pardon. So Nixon contemplated pardoning himself. He asked his lawyer if he could do it. His lawyer said yes. At the same time, the prosecutors said no. And we would have had that slugged out in court if he had done it. But he decided not to do it. If he had said, I'm the President of the United States, and I think that the right policy here is for me to get a pardon, that would not have sounded in any way like a considered policy judgment. Instead, he resigns. President Ford pardons him. President Ford says, I'm the president, it is my considered policy judgment that Nixon should be pardoned, and then loses the election because of it. Ford loses the election 2 years later because he pardoned Nixon. I mean, there are a lot of factors. When you only lose by a little bit, there's hundreds of things that made the crucial difference. But that's the way it's supposed to work. A politically accountable president making that call. So I think you're right, but think how difficult it would be to have a president pardoning himself and have that announcement that this is a considered policy judgment, not self-dealing, ring true. I don't think it would.
Well, turning to pardoning associates, and do you think there are any limits at all to the president who may be engaged in criminal conduct with others, a conspiracy? Are there any limits at all to his pardoning co-conspirators? And if you do not believe there are any limits at all, what does that imply about any consequentialist arguments regarding a self-pardon?
Yeah, I mean, that's the problem they confronted at the convention. They were debating, what if the president is leading this band of traitors and he pardons all of them? And the response wasn't, no, he can't. Like, they specifically voted to allow him to pardon his co-conspirators. But hold him accountable, impeach him, prosecute him, not say that the pardon is invalid. They trusted that giving the president this strong power was worth it, even though it could be abused, potentially, and the remedy would be, again, political, and it would be against the president. So I think if the president wanted to pardon everyone in his administration for anything they might have done, that would be valid. That would be that would hold up in court. What it would not do, however, it would not protect them from state prosecution, which is an important check on that. It would not protect them from impeachment. It would not protect them from civil liability for anything that they did. It would not protect them from social ostracism, right? Like their reputations would be adversely affected by this, I would hope. And to the extent that he was buying their assistance in a criminal enterprise, if the president said, go commit all the crimes you want, I'll pardon you, just give me a cut of whatever you rake in, that itself would be a crime. So the pardon would be valid, but the corruption underlying it would be a crime. And his co-conspirators could be prosecuted for that, and he could be prosecuted for that. And the pardon can only reach past acts, so the pardon itself being a crime would not be something, even if he could pardon himself, if pardoning himself is a crime, he couldn't pardon himself simultaneously for the crime of pardoning himself. He'd have to issue a new one, and then a new one for that, et cetera, and eventually his term ends. That's a footnote in my article.
Regarding social ostracism, I believe that when Ford was dealing with the blowback from the Nixon pardon, he at least claimed to have carried a copy of the Supreme Court case in his pocket, and anytime somebody questioned him about it, he'd pull it out, and he understood this case as saying that, well, if you accept a pardon, that means you're guilty. And I actually showed that Nixon was guilty of crimes through his acceptance of a pardon. So I actually did not let him go. I did not let him off the hook. This is issue as to whether a pardon means you're guilty has also popped up in connection with the Sheriff Joe pardon. Does the fact that he accepted the pardon mean that he was actually guilty of underlying crime? I was hoping that it's a question of some debate. What are your thoughts on whether accepting a pardon means you're in fact guilty?
With all due respect to President Ford, who I have the utmost respect for, not just because he went to Michigan as an undergrad and to Yale for law school, and I mean he was probably better at football than me. But other than that, I tried to do things his way. I think he got that wrong. Most pardons are for forgiving guilty people. An argument I've heard a lot about why a self-pardon isn't worth talking about is they say, well, a pardon means you're guilty. And if a president pardons himself, then he's saying that he's guilty of something, and he would never say that. He would never admit that he's guilty of something. So it's non-issue. It's true that most of the time, almost all of the time, a pardon is for forgiving a guilty person. But it's not inherently so. It doesn't have that legal effect. If you pardon someone, you're not declaring them guilty. You might premise the pardon on the fact that they are guilty, that they were convicted, and not say in the pardon anything otherwise. But pardons can also be used to exonerate people, and they have been used to exonerate people. President Ford exonerated after there was this World War II, a long time ago, I know, but there was a woman nicknamed Tokyo Rose who was convicted, sent to prison for making propaganda broadcasts out of Japan during World War II. And it turns out she didn't do it. And 60 Minutes ran a story about it, and it was clear that a grave injustice had been done. And so President Ford pardoned her. Not because she was guilty, and she accepted it not because she was guilty, but because she wasn't. So legally, it might not be convincing to people as a political matter or as a factual matter, but legally, there's no reason a president couldn't say, I'm pardoning myself because I'm innocent. I'm not forgiving myself for doing something wrong. I'm protecting myself from this runaway prosecution. And I think that would be valid. Again, it might not be persuasive, but legally, I think it would be valid, with all apologies to President Ford.
So I think we'd love to hear comments and questions regarding pardons or any aspect of self-pardons, pardoning associates, consequences of pardons from folks in the crowd.
Great, and any questions will have to be delivered through the microphone.
I just want to go back to something that I think you said a minute ago, and I was going to ask about, but I think I'm right about. In other words, impeachment is not a pardonable offense by the Constitution. It is excluded from the pardon. So in the Nixon case, as he's debating whether he's pardoned himself or not, is it likely that the politics would have contributed to him saying, no, I won't pardon myself because they'll almost certainly impeach me at that point?
When he was contemplating this was in August of 1974, so end of the line. The option he considered was pardon myself and then resign immediately. Now, there is a notion of impeachment that says that you can impeach someone even after they've left office. It's almost never going to be worthwhile, but technically you can do it, and it was discussed with regard to Nixon. But they probably, that's chapter 5. But I think Nixon did not see impeachment as a possible consequence of the self-pardon. I think he saw further public ignominy as the only real consequence of that.
Hi, thanks first of all. I wanted to ask you about your historical rationale for the pardon. So if I'm hearing you correctly, if I understand what you're saying, basically your contention is that because the founding fathers, the framers of the Constitution, debated that there should be a broad power of pardon, right? So the president could hypothetically pardon, say, co-conspirators, associates, or whatnot, and that the legal remedy for that is impeachment. So it's a political remedy rather than a strictly constitutional one, right? Am I understanding that correctly?
Well, they said he could be. They said, what if the president is among them? What if the traitors are his instruments? And the response was, then he can be impeached and prosecuted.
Okay.
Prosecuted.
I guess my question is, why can you not use that same logic to the self-pardon as well? You know, why can't you take that story that rationale and just extend it one step further and say, listen, maybe this power of the pardon is actually even broader than they originally thought, and that the reason why it wasn't entertained is because the same remedy for dealing with co-conspirators would be the remedy for dealing with someone who decided to self-pardon as well. Right, so that just like with co-conspirators, someone attempting to self-pardon, the remedy for that is a political remedy via impeachment rather than. Does that make sense?
Yeah, when James Wilson said he can be impeached and prosecuted, if he had just said, well, then he can be impeached, then I would agree with you.
Okay.
Because impeachment is the remedy for bad pardons, right? Political fallout. Extreme version of that, impeachment, is the remedy for bad pardons. And there's nothing about self-pardons that makes impeachment any worse of a remedy for that. But he said, and prosecuted, which to me suggests that he thought that the president could not pardon himself, because if the president could pardon himself, then he couldn't be impeached and prosecuted, and that wouldn't set their minds at ease at all. The only way that would work is if they were saying, well, maybe he would restrain himself, right? And this is the hypothetical is of a president who is a criminal leading a band of traitors and pardoning everyone he can, so that's not someone who I think would restrain himself. And so I think the and prosecuted does a lot of work for me there. And I know I'm putting a lot of weight on, Madison's notes of the debates. We don't know what anyone actually said, but I think, you take what you can get. I think that phrase, and prosecuted, makes a difference.
Okay, yeah, thanks. That actually clarifies the position. At least for me, it does.
Hi, thanks for being here. Mike, I think I've just gotten confused about when pardons can take place. And can people be pardoned before they've been found guilty? That seems like a granting of immunity. I'm just wondering if there's any difference between that kind of a pardon, between pardoning and granting immunity. All the cases that we're talking about are cases where someone has been found guilty of something. So I'm just curious about.
Yeah, Lincoln, Johnson after the Civil War said anybody who pledges loyalty to the United States shall be pardoned, even though they didn't actually prosecute every single person who joined the Confederacy. Draft dodgers were pardoned by
Ford and
Carter. There's wide-scale pardons of thousands and thousands and thousands of individuals. The restriction is that the bad act has to have occurred, or the allegedly bad act. You can't pardon somebody for what they're going to do. It has to have been something that has been completed.
So what would a president pardon themselves for that would not be a confession?
Well,
the Nixon pardon, Ford pardoned Nixon for any crimes that he committed or may have committed while in office. So it didn't have to be specific, and it wasn't. And Nixon hadn't been charged with anything. He was an unindicted co-conspirator.
And somebody could theoretically pardon himself for picking his nose. There's nothing illegal about picking your nose, but we fear malicious prosecution of the next president. I mean, to say this cannot be pursued at all in courts. So it's possible.
Hi, thank you for being here. You've used the phrase I forget exactly how you put it, but like a wrongful pardon, like it wasn't a good pardon. Can you explain kind of what that means?
Well, presidents make policy judgments, and we might disagree with them. So when Bill Clinton pardoned Mark Rich, to me, that was a bad pardon. What I mean by that is he shouldn't have done it. The pardon is valid. If you want to impeach President Clinton for doing that, you can, even though he left office some hours after the pardon. And if he had done it in exchange for a bribe, if it was a bad pardon in that regard, if it was a criminal, corrupt act, again, the pardon would be valid, but the crime, the corruption, would be prosecutable. He was investigated by the U.S. Attorney in New York and cleared, eventually. A young U.S. Attorney by the name of Jim Comey cleared him of that. But yeah, bad pardon just from a policy standpoint or from a corruption standpoint.
So is there anything that would go against pardoning people for like political gain? I think you could possibly argue that Trump pardoned Joe Arpaio to appeal to his base. So is there something that's illegal about that or impeachable about that, or is it just kind of wrong and that's how we can see it, but it doesn't make a difference in impeaching him or?
I would say doing it for political purposes sounds bad if you don't agree with political purposes, but it's great if you do. So personally, I opposed the Arpaio pardon. I thought that it was, even if it was justified, it wasn't justified at that point, and I didn't think it was justified anyway, but that's my personal take on it. If a majority of the House of Representatives thinks that it was a high crime and misdemeanor, then they could impeach for that. That's proven difficult to do, right? It's hard to get impeached if you're the president. But at a certain point, sure. And then look at President Carter pardoning the Vietnam draft evaders. He did that because he thought it was the right thing to do. Maybe he did it because he thought it would be politically popular. Maybe there were a lot of people who were sympathetic to the draft evaders who would say, hey, he helped out these people who we think deserve to be helped out. And if you agree with that, then it's a great exercise of policy judgment. If you disagree with it, then it's political pandering of the basest sort. And the president has that political accountability, so he has to make those choices. Carter was going to be running for re-election, so he had to do what he thought was right politically, and that's the system we've got. It's a political question.
And sometimes that fails, especially when you have the midnight pardon someone on the way out of office. And sometimes I think there's just no legal answer. If on his last day of office, Obama or Trump just pardoned every single federal inmate in this entire country, legally you would say, well, look at the Constitution, he has the power, they're all valid. But that's not a question for law to answer. If the president guns down all members of Congress, we're beyond the point in which a document will save us. That would be a constitutional crisis. And so if it goes too far, I wouldn't necessarily be dissuaded or concerned about one legal interpretation or another. There's just some things that the law isn't going to answer for us.
Sometimes the Constitution tells us how to arrange the deck chairs on the Titanic.
Seems like the earlier question I appreciate about what exactly is inside of a pardon and how broad it can be. If the president can pardon himself or herself for their entire life up until that moment they pardon themselves, pretty much they can't be prosecuted until they left office, and presumably they just lead a good life and avoid prosecution. It seems to me that that just puts the president above the law. Is there, which goes to the next question. I mean, is there, it seems to me that that itself would be a suggestion of a form of government that we want to avoid. But am I right that he could just prompt, he or she could pardon himself for everything up until the point that they stand for pardon?
Assuming a self-pardon is valid.
Yeah, which seems like it'd be pretty contradictory.
It wouldn't reach state crimes.
No.
We've only had one convicted criminal ever elected president. George W. Bush, you may remember a couple days before the 2000 election, it was revealed that he had a DUI conviction decades earlier. It was a state conviction, and that almost cost him the election. Came out, right, he was up here in the polls, that came out 2 days before, and he took a big hit from that. So, I guess what I'm saying is that's a pretty hypothetical, because the idea is that a president would be able to get elected despite having a lot of things to pardon himself for. But if he did, and if he had that power, then he could do it. I think that's a threat to the rule of law. But you can't push that argument too far, because by that same measure, every pardon is a threat to the rule of law. Right? Every pardon, by its nature, is taking a legal judgment or a possible future legal judgment that would result in a conviction or did result in a conviction and punishment and wiping it away. And so it has that inherent tension in it. And the reason we have it is because we recognize that sometimes the system gets it wrong. Sometimes people don't deserve to be convicted. Sometimes people don't deserve the sentence to be the extent that they got it. Maybe they should have it commuted. So it's a safety valve.
The pardon was, another way I got this idea from, was partly argued for as an idea that somebody should be able to prevent political prosecutions of people. Someone should be able to, pardon draft dollars, things like this. But I guess I'm concerned, I think that this notion of sort of pardoning yourself for everything at a federal level and pardoning your co-conspirators seems like that's an argument of reducing the Constitution to absurdity if that was allowed. I mean, isn't that part of the argument that the whole system just would fall apart if that could be true?
I mean, I think our Constitution, any government ultimately has to rely that people act in good faith. There's just, you cannot legislate ethics. You cannot force everyone to behave well. There's many powers that can be abused. The president could lawfully drop a nuke on Canada, for example. And if you assume that everyone is going to act in bad faith, then we just get to the point where the Constitution doesn't matter anymore. It's not a legal question. I think for the system to work, you think about the Bill of Rights in Soviet Russia. It was much more extensive than ours. It's a beautiful document. But if you have bad people enforcing it or protecting it, it's just not a legal question anymore. And so the Constitution, as interpreted, I think permits many bad things. Whether the self-pardon is one of them, I think is an open interpretive question. But the fact that the Constitution does authorize bad things, I don't think that's not debatable, generally.
Sometimes it mandates that.
Yeah, it protected slavery for 25 years.
Oh, good.
I'm intrigued by the debate in Philadelphia and the discussions. One thing that occurred to me as I was listening to you is this idea of the ballot box as, providing the ultimate accountability. But they did not have a concept of a two-term limit. So theoretically, any president in their mind would have to be accountable because they could keep running and running. They would never be term limited. And so that probably never occurred to them that maybe it wouldn't be because we limited them to 2 terms.
Well, I think term limits make it more problematic to have a broad pardon power, not less, because of the fact that you've got that long lame duck period. But I think political accountability is more than just presidents being reelected. It's presidents having a program that they want to get through Congress. It's presidents wanting their nominees to get confirmed by the Senate. It's any one of a number of things that a president wants to do while in office, even in a second term.
And I think this political accountability point is recognized. It's popped up again with respect to the Comey firing. Nixon allegedly fired somebody for a very bad reason and was sued civilly. And the United States Supreme Court said you cannot sue the president for his official acts. Usually you can sue somebody who does something wrong to you, or wrongful discharge. And the Supreme Court said, well, there are remedies. 1 is impeachment, 2, we have a press, and 3, people have to look at themselves in the mirror, including the president. Those were the remedies offered. And I think that's what you're left with a lot of the time.
I think it's worth noting that in that decision, if I'm not mistaken, the dissent cited the principle that no one is above the law. Right? If they're saying that someone is immune, they're not going to mention that. Maybe the dissent will mention that. But if the majority says this person is subject to the law, they will say because no one is above the law. And so, again, that's an inherent limit I recognize in all the arguments I'm making is courts uphold these principles, except when they don't.
I have one question. The historical record itself on pardons, is there a document, a pardon document? If so, where is it archived? Is there anything like a signing statement or any elaboration about the rationale?
We were talking, well, it depends on the president. For a long time, Lincoln was known to handle pardon requests personally. And it was a problem because his advisors would say that he could never turn away a weeping widow. And they would seek a pardon for their husband, son, and he would grant pardons routinely. After Lincoln, there was a more formal process. For about 4 decades, different presidents, 1890 to 1930, actually published the reason for every single pardon. And so you would see things like, winter is coming, you may destroy these crops. Take him out of jail. This person is innocent. There's doubts about guilt. And then for the next 30 years, all that was published was number of requests and number of grants. And so it takes different forms. I mean, you could talk about more modern practices.
Yeah, well, the more modern practice, so there's a bureaucratic process where presidents not wanting to face the Lincoln situation delegate this job to the office of the pardon attorney in the Department of Justice. And 99% of the pardons that are issued go through that process. And so you have a record. You have their application. You might have some internal memos recommending granting it or not. Those recommendations go to the president. Presidents recently, in recent decades, have been fairly stingy with the pardon power. So the pardon attorney is pretty stingy, and then the president is pretty stingy from that. But we have for anyone that is granted, we do have that record backing it up. The pardon attorney will not recommend a pardon unless the person is 5 years past their conviction or sentence and has shown remorse. And again, that reinforces the notion that pardons are for the guilty, for forgiving the guilty. But I'd say 99% of the pardons that are issued go through that process. 99% of the pardons that make headlines don't. And the president is always free to just do whatever he wants with the pardon and not rely on that bureaucratic process.
I would say if, for example, President Trump wrote on a napkin, "I pardon you," and handed that to his son.
A tweet.
A tweet. A tweet would be public at least, but just on a constant napkin, I think it's far from obvious that that would be invalid. In fact, it may be perfectly valid. Just, he may have pardoned himself. Just, I pardon myself, stick it in a drawer, and that's it. There's no law on it. Typically what would happen is if you were prosecuted, you would have to prove to the court that you had received a pardon. And if you just said, "Oh, the president whispered, I pardon you," that isn't going to hold up. But yeah, in theory, I'm not aware of any requirement that it has to be tweeted, it has to be announced from the Rose Garden. The only limitation is that you would have to convince the court that you were, in fact, pardoned. Regarding the more restrictive use of pardons today, historically, there were a lot more pardons. On the federal level, there was only one level of murder, first-degree murder. So if you killed somebody, you faced that. And now that murder is just different gradations, that has made a lot of the sentences more sympathizing. Also, our Constitution's due process limits have expanded greatly over the last couple hundred years. And I think a more articulated set of federal offenses plus due process protections has arguably shrunk the number of federal prosecutions that need the help of the pardon power.
Thanks so much. This is the sort of exchange which I think will stick with us. And we'll be thinking about what you said, maybe not this term, but in the future.
All right. Thank you.
Awesome.